The Dilemma of Payment of Gratuity Daily Workers and Contract Workers by C-Quel. The issue of payment of gratuity for employees whose services are regularized from daily wage employees or contract employees to regular employees has always been a perplexing question. The moot question in such situations is whether the workers are eligible for gratuity for the period they were employed as daily wage labor or contract labor, and whether such period of service is eligible for the payment of gratuity. The question was settled among other cases, with the 2018 decision of the Honorable Supreme Court in Natram Sahu vs State of Chhattisgarh 1. It was held that daily wage employees are eligible for gratuity for the total period of employment. Natram Sahu was appointed as a daily wager on the 1st of April 1986. He worked for 22 years as daily wage laborer and 3 years as regular employee. It was held that the employee was eligible for gratuity from the date he was employed, thus entitling him to gratuity for the total period of 25 years irrespective of the nature of employment. We can see that the courts are now applying this principle in the recent judgments. Lately, in the decision of Chief Executive Officer vs K.V. Puttaraju, 2022, the Karnataka High Court reiterated this principle. Relying on the judgment of Honorable Supreme Court in Natram Sahu, it was held that the total period of employment beginning from the date of their induction as daily wage employees should be taken into consideration as qualified period for payment of gratuity. Regarding determination of interest on gratuity, as there was lapse in filing applications for claiming gratuity, it was held that the petitioner was liable only to pay interest thereon at 10% per annum from the date of the applications till the date of deposit. In yet another latest decision of SMT Mahadevarma vs Assistant Executive Engineer, Karnataka High Court, 2021, the Karnataka High Court relied on the SC judgment of Natram Sahu and held that having regularized the services, the person would be eligible for gratuity for the total period of service under the Payment of Gratuity Act. It is interesting to note that even before the SC judgment, similar line of principle was applied in one of the judgments of Assistant Executive Engineer vs Shritamane Gaurav. Conclusion. The central question of whether employees would be eligible for gratuity for the period they worked as daily wage laborers is no longer a matter of res integra. If employees are denied gratuity for the long and continuous period of service they have contributed, it would be considered blatant non-compliance. Have questions? Ask C-Quel.